Now, with judicial precedent now, right, we know that this is usually called case law, and a lot of my slides throughout these PowerPoints will have a slide called case law on it. Right, so looking at the precedent, right? So it refers to a body of past decisions made by courts which serve as authoritative guidance for future cases. Right, so courts often rely on precedents to interpret statutes, right, resolve disputes, and establish legal principles. So we're looking at this rule, right? This judicial precedent, which is a source of law, historical source of law, right? So let's look at this. So we're starting with the general principles. So decidendi, right? So ratio decidendi, right? Or Latin for the reason for deciding is a legal principle for reasoning underlying the court's decision. It represents the essential grounds on which the decision is based and forms the binding part of the precedent. For example, in the case Donahue v. Stevenson, 1932, the House of Lords established the principle of the duty of care owed by manufacturers to consumers. This becomes the ratio decidendi of the case, guiding subsequent decisions on negligence in tort law. Right? So we're looking at that. So the ratio decidendi is the reason for the decision. Right? Obiter Dicta. So this speaks to other things said or refers to remarks made by the judge in the court's decision that are not strictly necessary to the decision itself. While not binding, right, obiter dicta can prove as persuasive precedents. So you have binding precedents and persuasive precedents, right? So obiter dicta can be persuasive but not binding, right? So in Donahue v. Stevenson, we can look at an example of persuasive precedents, right? Additional remarks by the judges regarding the concept of neighbors and the scope of duty of care constituted obiter dicta, offering insights into broader principles of negligence law, right? So notice how it can actually lead to some amount of precedents, right? So it's persuasive. So I have obiter dicta there. Many obiter dicta, one obiter dictum, all right? So we could look at that. Stare decisis, right? For Latin for to stand by things decided or to let the decision stand, right? Stare decisis is the principle that the courts should adhere to precedents and follow decisions of higher courts within the same jurisdiction. So this principle promotes consistency, predictability, and respect for established legal principles. For example, the doctrine of stare decisis requires lower courts to follow the decisions set by higher courts within their jurisdiction, such as decisions of the Supreme Court. Everything is fine so far, guys? So remember, if there's an issue, you stop and you raise your hand and you go. Right, you just stop me. Okay? Distinguishing a precedent now. Distinguishing a precedent involves identifying the differences now between the facts or legal issues of a current case and those of the precedent, right? So when significant distinctions exist, the courts may decline to follow the precedent, right? So if a court is presented with a case involving unique factual circumstances not addressed by the existing precedent, it may distinguish the precedent and reach a different conclusion based on new facts, right? So let's say in one scenario you stole an orange, but in this scenario now you stole a car. These are the same thing, stealing, right? But the facts of the case are significantly different. So you'd have to distinguish the precedent there. Alright? We have overruling a case as well. So overruling a case occurs when a higher court expressly, right, decides that a previous decision was incorrect and no longer represents the law. Overruling rather, nullifies the precedent and set by an earlier decision. So, for example, Brown v. Board of Education 1954, the U.S. Supreme Court overruled the precedent set by Plessy v. Ferguson in 1896, which had upheld racial segregation, declaring the segregation in public schools was unconstitutional. So looking at there. Now, overruled case, an example is Brown v. Board of Education 1954. Right? This is a US case though. Alright? Res judicata. Latin for the thing adjudicated, right? So it's the principle that once a matter has been decided by a competent court, it cannot be relitigated between the same parties. Cannot. Right? So res judicata prevents the same issues from being endlessly litigated over and over again. For example, if a plaintiff sues a defendant for breach of contract and the court renders a final judgment on the matter, the plaintiff cannot subsequently bring another lawsuit against the same defendant based on the same breach of contract claim. You can't do that. So res judicata basically speaks to the fact that it has already been adjudicated already. You cannot bring the same thing again. Right? So it prevents re-litigation over and over again. Alright? Per incuriam is the last of these terms. Right? So it speaks to, right, it's Latin for through lack of care. So it refers to judgments or decisions that is made without proper consideration or relevant legal authorities or principles. Such decisions are considered to have been made in error and may not have binding authority. So for example, if a court renders a decision that overlooks a binding precedent or misinterprets the law due to oversight or mistake, it may be considered per incuriam and not followed in future cases. Alright? So looking at that. So it's different from being overruled, you know. Because some persons tend to mix it up. Per incuriam means that a mistake was made. Overruled just means that a higher court made a different decision. It's not that the decision was wrong, just that the higher court made a different decision. Alright. So that's really it. Under there. So we know the decision of stare decisis would allow us to actually gain some amount of historical precedent, right? So historical source of law. So if something similar was committed in the past, right, that thing now has some amount of precedent, so the legal system can now look back on it and gain some amount of knowledge and insight from that previous case, right? So it allows for the predictability of the court system, and that is important within the rule of law. So consistency is key here. Any questions or concerns? Any questions or concerns? Everybody is fine so far? No? Okay, everybody's fine.